Good afternoon and welcome. I am Vivian King, former CEO of RELO, the Trade Association for the Retail, Leisure and Placemaking Property Market, and I spent much of last year deliberating over CVAs. Thank you for joining this webinar run by Davitt Jones Bould and Legal Business on the implications of the new restructuring regime introduced last year, specifically cross-class cram downs, I have to say that slowly, and the very new and radical test of that regime in the Virgin Active case sanctioned just last month and currently being tested in the NCP case. We will be taking questions should members of the audience have questions through the chat function, so please do send them through. But I do need to point out that we have a very large audience and a very packed agenda, and if we can't answer your questions during the course of the webinar, we will aim to do that afterwards. We have a stellar lineup for you today, and I'm just going to ask the panel if they would please introduce themselves.
Hi everybody, my name is Jonathan Warner-Reed. I'm a partner with Davitt Jones Bould. I'm a property litigator for my sins and have been for the past 20 years.
Hi everyone, thanks for coming to the webinar today. Looking forward to the discussion. My name's Tom Baker. I'm a senior reporter at Legal Business and I've covered the legal industry for the last 4 or 5 years for my sins as well. Really looking forward to the debate. Hopefully you'd speak again in a little while.
Hi, my name's Camilla Lamont. I'm a barrister at Landmark Chambers. I specialise in property litigation. I've advised both landlords and occupiers in relation to CVAs, and I was one of the council team that acted for Debenhams in relation to the unsuccessful challenge of its CVA in 2019.
I'm James Birchall, co-founder and partner at Telon Capital, a commercial real estate investment developer. We've got about £250 million worth of retail investments and developments, ranging from high street shops through to city centre regeneration and developments and shopping centres and district centres in the southeast and southwest, as well as core office buildings in central London, where we happen to be Into's previous landlords. So an exceptional relationships and understanding with what's been happening with retail occupiers as a landlord and investor.
Thank you all very much indeed. Right, before we get into the debate, Jonathan, you're going to give us a short presentation, I think, on the background for some context, aren't you? So over to you.
Okay, thank you very much, Vivian. Yes, I thought it would be useful to have literally a whistle-stop tour of how we've got to where we are. I'm just going to look at the road to reform. Obviously, Part 26A of the Companies Act 2006 is the provision that we're looking at. And the reason why I think it's good to give a whistle-stop tour is because a lot of people think that this all stems out of the pandemic. And it actually doesn't stem out of the pandemic. We have to go back to May 2016 and the government's original proposals. And the spur to these proposals was actually the World Bank's doing business rankings. The UK didn't do particularly well, and they were a little bit aggrieved at that. But the reason why they didn't do very well was they fell down in the resolving insolvency rankings. So they were particularly peeved as well that China apparently was a better place to do business than the UK. So they actually thought, well, we need to do something about it. That's the explanation as to why the legislation was introduced. What it doesn't explain is the cram down mechanism. That actually wasn't discussed in the World Bank's report at all. The reason for its inclusion appears to have been a desire to actually emulate part of Chapter 11 of the USA bankruptcy code. That's what it was. That's where the cram down bit comes into it. So what were the original proposals? Well, the government actually wants to introduce cram down provisions allowing for a restructuring plan to be imposed on a junior class of creditors, even if they vote against the plan, as long as they'd be no worse off in a liquidation. So in support of these reforms, the government cited World Bank Principle C14.3. I won't bore you with what that says, But what you do need to know is that that also doesn't mention cross-class cram downs either. And again, we're going back to chapter 11. So many responses to the initial consultation were actually very unenthusiastic. And the reason why they were unenthusiastic was they thought that the government was overreacting to these business rankings. So that's the background to it. I just want to touch upon a few issues which are quite controversial. So the first one is the financial difficulty threshold. So in the new regime, everything is more forward thinking. So the financial difficulty threshold is you're likely to become or experience financial difficulties. Now, just saying that, the problem that we're going to have is what are the limits of that? You know, it's an unrestricted test of financial difficulty. How do you gauge that somebody will be or is going to be in financial difficulty? The government tried to appease this so that although this permits a company to propose restructuring in a wide range of financial circumstances, there is a requirement that any restructuring for a particular has to be for a particular purpose, namely to address those financial difficulties. So the condition is plainly intended to limit the permitted nature and effect of restructuring under Part 26A. It has to address financial difficulties rather than have any other purpose. The risk is that people could use this process, I guess, for some extraneous or collateral purpose. So that's the other thing that we've got to be aware of. The other thing I just want to touch upon is the creation of classes. So people are put in certain classes. So this is the gateway to the cross-class cram down. So it's called the someone likes it rule. And that's what controls access to the cram down power. So there will be an incentive, be it for the company or another creditor, to constitute classes to ensure that there is someone who does like the proposal in order to cram down somebody who doesn't like the proposal. So the question posed by the new legislation is what limits, if any, should the court set on the constitution of classes? Because that is exceptionally important. The government has tried to appease us again by saying, well, you know, any of these proposals has to be sanctioned by the court, and the original plan was for it to be just and equitable. The Chancery judges took exception to that and said it states the obvious because the court won't approve anything that isn't just and equitable. The government's response to that was not even to include that as a standard that the court should adopt. So that doesn't find its way into the new legislation. So some of the takeaway points that I just want people to be aware of: Part 26A as enacted is much broader than the government's initial proposals. It does provide an opportunity for the English court and restructuring profession to develop restructuring proposals, which thus far haven't actually been seen by the courts. So it's very wide ranging. It will provide challenges and opportunities, I'm sure, for companies, creditors, and the court and all restructuring professionals. And also the development of new and appropriate principles is unlikely to be straightforward. And as with Chapter 11, the law itself may undergo amendments to fine tune that process. I just want to quickly touch upon the Virgin Active case. So Virgin Active was obviously a successful gym chain. They had to close as a result of the pandemic. That put them in financial difficulty. So that was the reason for going down this cram down process. They put forward proposals. Those proposals, some of the creditors didn't actually understand the proposals. Some never received the proposals. It was all very rushed. And it was very rushed because Virgin Active said, if these proposals are not passed by the 10th of May, it means we will have to go into administration and there will be a lot of jobs at risk. So that was the background to it. The judge said, well, I'm going to push it off to creditors. They can have their creditors meeting, at which it was approved because obviously everybody was put in their classes. They knew that they would probably be able to get it through. It came back for the sanction hearing. Court was very good and sat over the May bank holiday for 4 or 5 days, and the proposals were given the go ahead. So lots of disgruntled landlords. So that is a very quick whistle stop tour of where we are and how we got to where we are now. So I'll hand back to Vivian. Thank you.
Thank you very much, Jonathan. Well, I'm going to start with a market view of this, James. So you thought CVAs were problematic, and Jonathan's talked about the potential for this new regime being used for a collateral purpose, where does this leave the investment market in the UK?
I think this creates significant challenges. And when we talk about the investment market, challenges are right the way across the board. There's always an assumption, and we know the government has sort of believed that most property owners or commercial landlords still come wearing their sheepskin coat and smoking their cigars. But the commercial real estate market has moved on significantly since then, and is really, investment-wise, there are a significant number of private investors. They hold commercial real estate in their pensions. The pension organisations hold between 8 and 10% of their holdings in commercial real estate. And this is a real significant challenge. The real problem is that actually when you look at the history of CVAs, and Camilla, I know you were involved from the Debenhams as well, okay, that there has been a history of a succession of companies that have been either privately owned and badly run, or private equity owned, where they have been private equity vultures that have gorged on a diet of debt and dividends, that have then decided that they will throw the carcasses in the landlord's direction, and leaving them purely to pick over the pieces of what is left. Now, the problem with that is that the landlords as unsecured creditors are the ones that are being significantly affected. And the problem is that it's a really short-sighted approach. And whilst everybody understands and has a great deal of respect for businesses that are struggling, especially during the COVID era, but a lot of these businesses have not struggled, okay, because of COVID. They've struggled because, and NCP is another example of this. And if you take Pizza Express, which was another example of the CVAs, where the average Pizza Express restaurant was loaded with £1.5 million of debt per restaurant. Okay, you are just seeing an example here of where investors are going to not be able to trust an occupier to be able to pay its rent. Real estate is a balance of risk. It's a risk and return. And part of the pension funds who invest over 100 billion in real estate, okay, are going to be looking at this and think, where do we put our money? Why should we be investing? Developers will not invest in new town centres or in regenerating town centres because there's no certainty. What we're seeing is an abuse of a system that was set out with good intentions, but without seriously considering what the implications are. And long-term investors are seriously struggling because it means that a lease no longer has any validation, no longer has any security, and there is no longer any trust. And if you can't trust a business to operate as you anticipate, then how can you trust to invest in that business? And effectively, real estate, we are suppliers. We're suppliers of a product. We only supply that product to occupiers who want to take it. But those occupiers who take it, when the good times, they're quite happy to pay the premium rents. But the moment there's a challenge, they want to abuse that system. Then it's going to have a significant long-term impact on the viability of future town centres from an investment perspective. And whilst from a personal perspective, I have a great deal of sympathy for the operators of Debenhams as a great example. That were bought by private equity, split into an opco-propco, stuffed into long-term leases that were no longer viable. The private equity took all the dividends out, floated the business, stripped it all out, and left the business handcuffed behind itself, unable to trade its way through. And so the real challenge is finding and understanding from an investor's perspective who are operators who trust, that they will be able to work with, that they're going to be sustainable, that are going to sign a lease and pay the rents.
Okay, so Jonathan, having heard James's colourful perspective there, could it be said that in fact those premium rents actually have been too high and landlords have been refusing to compromise, if indeed they should be compromising, and that's actually what's resulted in an increased use of insolvency regimes as really the option of last resort for struggling occupiers?
Yeah, well, I tend to agree with James. I think rent is dictated by the market. if I've got a high street shop and I want to rent it for £15,000 per annum, and somebody comes along and offers me £17,000 per annum, I'm going to take the £17,000 per annum. So rent is dictated by the market. We go by open market rent. We instruct surveyors to tell us what is happening in the marketplace and what I can reasonably expect to get. No, I don't think it's the landlord's fault for demanding escalating levels of rent. I'll give you an example. I call it the Bond Street example. The building that Chanel operate out of on Bond Street came up for sale. And Chanel, rather than rent it, decided that they were going to buy the whole of the building. I think it went something like £310 million. It was a lot of money. If you look at other businesses on Bond Street, such as Boodles, which is a family-run jeweller's shop, I think their property is worth something like £70 million. They pay rent of in excess of £2 million. Now, the return on investment there is actually pretty low. It's below 3%. So that's not a landlord demanding escalating levels of rent. That's not a brilliant return on investment. I appreciate there may be capital growth there, but it's definitely not dictated by the landlords. The other thing, when the pandemic came along, the government released something called the Code of Practice for Commercial Property Relationships during the COVID-19 pandemic. And what that did was it encouraged landlords to talk to their tenants about how together they could navigate their way through the COVID-19 pandemic. And it gave suggestions as to how landlords and tenants may work together. Now, in my experience, I don't think I came across a landlord that didn't adopt the code and tried to come to arrangements with tenants. If I'm to be completely honest with you, I saw some naughty tenants who were open for business and were operating normally, who tried to use the whole COVID-19 pandemic to their advantage and not pay rent because it was better accumulating in their bank account than handing it over to the landlord, and there was nothing the landlord could do about it. So I think landlords have actually engaged with the whole thing. I don't think they're the ones to blame. And as James actually touched upon, Debenhams is a very good example. It was loaded with debt and costs. And if you look at why that entered into a CVA, it wasn't because their landlords were demanding escalating levels of rent. It was because of all the reasons that James said regarding its structure and refinancing, but it was also lagging in fashion trends. And it did have too many stores and too many sales. If you remember, I think we can all remember the Blue Cross sales. What would happen is nobody would shop at Debenhams. They'd wait for the big signs to go up outside saying it's a Blue Cross sale, and then they would shop there. Well, you can't run a business like that. The other one that I briefly looked at was Arcadia, and I thought, did they go down, or did they enter into a CVA because the landlords were somehow at fault? Again, the landlords weren't blamed. The main reason there was competition. There were new entrants to the marketplace. COVID did play a big part of Arcadia's going into CVA. Costs, which was exactly the same as Debenhams. At the end of the day, they had big estates. Not that the rents were too high, they just had big estates. With big estates come bigger costs. The business rates bill is big. And also with Arcadia, there was a bit of controversy. People said that we're not shopping at Arcadia's shops because of the whole BHS thing and various allegations that had been made against Sir Philip Green. So I couldn't find anywhere where landlords were being blamed, and I don't think they are to blame.
Okay, well, thank you. Well, I was involved in drafting that code, Jonathan, so I'm glad to hear that it was put to use by parts of the industry anyway. Okay, so Camilla, your Debenhams case has been mentioned twice now. Of course, one of the challenges that landlords face if they want to challenge is the cost of doing so. So what sort of cost risk does a landlord face if they decide that they are going to take up the cudgels and they are going to mount a challenge?
I think the straightforward answer to that is potentially and probably a very significant one. Particularly in relation to challenging CVA sort of after the event. So for example, take the Debenhams case. I know that the costs order that was made against the landlord group who were unsuccessful in challenging the CVA in that case was a 7-figure sum. I mean, yes, Mike Ashley and the Sports Direct group were underwriting those costs, but the reality is that's a risk that most landlords aren't prepared to take, particularly on their own. There is potentially some good news here for landlords in that there's been a recent cost decision in the Virgin Active case, which has sort of slightly gone under the radar, but there was a cost decision after the convening meeting, but before the sanction hearing. And essentially the landlord groups were saying that they wanted their costs paid because they were saying, well, there's a general principle, we should have our costs paid on attending. And the court said no, and actually looked at what the applicable principles were. But it is clear that special rules apply in relation to the costs of plan hearings, and that it's not necessarily the case that the sort of costs follow the event. The costs were always going to be in the discretion of the court, but really the rules are sort of modified because it's felt important that creditors shouldn't be deterred from participating in the hearings where appropriate, particularly as it's a sort of discretionary procedure. So an unsuccessful landlord is not necessarily going to be ordered to pay the costs, but might be so ordered in an appropriate case. And there may even be cases where the plan company will actually be ordered to pay the costs of unsuccessful creditors whose participation has assisted the court. And in fact, in Virgin Active, 2 of the landlords who appeared, or a manager and a landlord, they were awarded their costs, although they were fairly modest. So I think the key point is that costs are always going to be dealt with on a case-by-case basis, but actually the position on costs might be more favourable for landlords under plans. And the key point is that I think landlords should be looking to be seen to be acting reasonably and proportionately in order to kind of minimise those risks. I mean, actually, just a final point is that I'm pretty sure we're going to have there's going to be a big hoo-ha about the Virgin Active sanction hearing costs, because I understand that Virgin Active are going to go against the ad hoc group for their costs. And I know that there are adjourned cost application made by the ad hoc group and another landlord for their costs. So I think there's going to be a head-to-head on that. So it'll be quite an important judgment to look out for.
Yes, so watch this space on that one. Well, perhaps Camilla, you and James would have a view on this. It seems to me that challenging a restructuring plan is rather like getting a camel through the eye of a needle at potentially eye-watering costs. So what now for property owners who are facing restructuring plans and CVAs? You're both being very polite.
Sorry, no. Yeah, Camilla?
Oh, well, I was going to say on that, I think the key takeaway, I mean, the press has been, the press reporting on this is quite polarized. These things are terrible for landlords, but that doesn't mean that landlords shouldn't challenge in appropriate cases. Virgin Active turned on its own facts, and there will be other plan proposals which will be much more susceptible to challenge. So I think really going forward that landlords should keep their eye on the ball, and they should scrutinise future plans very carefully and shouldn't shy away from opposing a plan in an appropriate case. I'd say the sort of general sort of guidelines that I'd say is, one, pick your battles wisely. There's no point battling every single plan because it's just going to be a waste of money, but there will no doubt be some proposals which are borderline or on the edge, and where there might well be demonstrable abuse or unfairness, particularly in the money cases, or if there is some sort of faux categorization of sort of shareholders' debts as critical creditors and things like that. Challenges are, the landlords are going to be better off if they act together where there is a challenge. And that's something we're seeing more and more of in CVAs. Definitely in terms of sharing the risk and the cost, that's a good idea. And also it's clear from the Virgin Active judgments that if you're going to challenge, there's no point doing a job half-heartedly. If you decide to challenge, then do it properly. And in particular, you should be looking to make very early disclosure requests and applications, particularly very focused disclosure applications, Really, it will be key in most cases for the landlord group to get their own valuation evidence, which is one thing that they didn't do in Virgin Active, which I think the court was critical of. So I think if you're going to go for it, pick your battle, go for it. And again, fully evaluate the cost risk of any particular case. And if you act reasonably and proportionately, that's sort of a generally good rule for trying to minimise cost risks.
I think picking up on a few things that Camilla talked about in terms of landlords acting reasonably and proportionally. I think a great example actually of where a CVA was pushed back was the Travelodge CVA, where landlords did get together in groups, where landlords did push Travelodge significantly. They varied the terms of the CVA, and actually Travelodge did themselves a little bit of a disservice because they ended up having to compromise some of their better hotels in order to get a CVA through. Another example, though, of the ultimate, I think they're called vampire squids in Goldman Sachs backed as a private equity business that was abusing the system. And I think if you go back to what Jonathan said right at the very beginning about Part 26A, about companies in financial difficulties and the financial threshold, I think that is really the key. And I think for a lot of landlords now, this has almost been a wake-up call in education. You know, historically, as we said, that the landlords are property operators and very simple in singular, even the institutions from that perspective were viewing this as a very simple acquiring a real estate asset, collecting rent, managing the asset, and that is what they needed to do. And surveyors, really, that was their expertise. Today, you know, real estate has become a far more complicated scenario with the advent and introduction of the more varied operators that we have. And again, going back to the ownership structures that we have. Today, landlords have got to become a lot more street smart. They have to become a lot more aware. It's no secret that we were involved in a collaboration against one of the large private equity retailers that was opened during lockdown that tried to prevent paying rents. And we put a collaboration together of a number of landlords in terms to negotiate with that occupier and understanding that. And I think that's going to be a real key. Today, it's not just about looking at individual retailers and perhaps their turnover. Today, you're going to need to do a lot more financial due diligence. You need to understand where the backing is coming from. You need to be able to argue a case. And this is probably something that will come on as occupiers move forward, and we're looking at more and more of a call. I'm jumping ahead a little bit, I know, on turnover rents, but part of that is going to be a partnership between property owner and property occupier. That if an occupier wants a turnover-based rent, they're going to have to be more transparent on their costs and their revenue. And I think this is a call, and you started to see this. We started with Virgin Active, we started to see it with Travelodge, we started to see it with Debenhams a bit more, of the real estate industry operators, the REITs, as well as the institutions and private operators, having to become more street smart, more financially smart, more savvy and more understanding of how these businesses are being run in order to demonstrate that actually, you know, if they're genuine issues, that's fine. But if they're genuine issues, if they're issues that have been caused because the owners have taken out billions of pounds worth of dividends over the last 2 to 3 years, then there should be a call in order for them to put that money back first. And this is the real difference in legislation between secured creditors and unsecured creditors and real estate owners, who seem to be the unsecured creditors who are penalised the most.
Okay, so Jonathan, are landlords penalised as unsecured creditors? Are they almost victims? In this, are all creditors equally penalised?
I think that all unsecured creditors are probably going to be equally prejudiced because they're all going to be crammed down. So those who are being crammed down are inevitably going to be prejudiced in some way, shape or form. I guess landlords going into leases originally have a little bit more sway in things because they can rely on other things such as rent deposits or getting guarantees. So they can enter into those kind of things at the outset. it's interesting that you mentioned when you asked the question about are landlords almost victims, and there's this whole villain against victim. For whatever reason, and I don't know why it is, landlords have always been seen as the villain. I don't know why. It's kind of, I think it must be a Dickensian thing, but they're always seen as the big bad wolf. And it's interesting because obviously when the pandemic hit, the Coronavirus Act 2020 came into force. It precluded landlords from forfeiting commercial leases. That's still continuing. They restricted the use of commercial rent arrears recovery, CRA, and they also precluded or were precluded from presenting statutory demands and winding up proceedings. Now, those are the main tools that a landlord is going to try and use to make sure that their tenant pays the rent. It's what gives them the leverage. So landlords, given all that came into effect at the beginning of the pandemic, we didn't know how long the pandemic was going to last, and that is still the case. Landlords at the moment are feeling pretty punch drunk, I think. And then along comes the Virgin Active case. I just want to quote somebody because I thought it was quite funny when I read it. It said, when the owners of Virgin Active were considering the options as to how to do over their landlords, they must have considered a cram down, if only for its innuendo and comedic potential. And I think there's a certain truth in that, because you have the Coronavirus Act, and then this comes along in June 2020, so 1 month into the first lockdown, and it's the first time it's now being used against landlords, forcing them to accept something that they would never ever have voted for, and yet landlords are just seem to have to kind of ride this out, which seems terribly unfair. And as James pointed out when he was answering one of the other questions, it's a very short-term view, because long-term, lots of pension funds and everything else have things wrapped up in real estate. So to quote somebody else, this whole Virgin Active cram down business, it's just another arrow added to the quiver of tenants. And to use an accompanying metaphor, it's another nail in the coffin that landlords are just going to have to try and deal with. Another thing that I just want to mention, and this is the scary thing from a point of view of restructuring professionals, which is, I've heard this being said, and this is the risk. It said the reason why everybody in their profession is getting terribly excited about the Virgin Active case is because it's still a new toy. This is a relatively recent thing, and they want to see how other people play with it before they get a go. So they'll see how it pans out. The risk there, though, the underlying current there, is that other restructuring professionals are going to pick this up when this all calms down, see how it goes, and then it's another string to their bow, isn't it, that they can use against landlords.
Yeah, very likely, Jonathan, very likely. So Tom, just thinking about the market-facing aspect of this, there are various options open to a landlord community when facing a potential restructuring. You can obviously try to negotiate a better position with operators, or you can mount a legal challenge, or in fact you could lobby long game this, but you could lobby for a change in the law. Tell me, what do you think might be the role for the media in lobbying for a change in the law?
I think first of all, it should be recognised that there should be a role. After listening to the very interesting accounts just now, it's clear that this is sort of an untenable situation from sort of the outside looking in, and it's very funny listening to Jonathan sort of wondering why this sort of villain versus victim portrait has been illustrated, and I'll have some thoughts on that to add maybe a bit later when it comes to the mainstream press in particular. But what I thought was particularly interesting from the perspective of this question, the idea of lobbying, is potentially the power of social media, even because I think that might be the best bet for landlords, quite frankly. I've thought, hashtag can take you quite far. It's worth a try at least. Of course, Twitter, if you wanted to go down that route to try and lobby for a change in legislation, it's kind of sort of both a PR tool in one sense, but also, you can lobby the relevant people in power if that's the sort of route you wanted to go down. Of course, as well, if you wanted to be particularly savvy, we talked about landlords sort of maybe needing to be a bit street smart. Twitter itself is a good sort of good way of monitoring public sentiment if you wanted to actually see the amount of people that were on your side, or that might be slightly grim reading, as we might get onto later. Although, of course, with Twitter, you do have to be careful that you're not sort of just kind of lent into a sort of echo chamber, as some people have termed it in the past. I think if you're thinking about the more mainstream media and trying to leverage them for some sort of change in legislation, it is important to remember that the mainstream media, it's pretty independently minded sometimes, at least. And I think I'll expand on this later, but I think there's a very strong narrative that landlords are going to have to come up against, and I think that's going to be a real uphill battle if they're looking to try and gain some kind of public footing in this. I mean, not to expound on it too much just yet, but I generally, from looking at the recent coverage of particularly the Virgin Active and New Look cases, it seems that while the business press have potentially given perhaps a fairer shake, a more balanced and more nuanced view, which I think is necessary because this is a very publicly important issue. The mainstream press in particular does seem to have quite a pro-occupier bias. And I think perhaps one reason for that is that I think the general public are going to identify with brands that they know versus kind of like a faceless sort of landlord type thing, and it's kind of reducing it to those stereotypes. But I think it sounds like a crude point, but it's worth considering. And finally, also, you've got to be careful not to fall foul of the law when you're lobbying. I was looking up on it, and you have to be very careful. So I'd ask them to bear that in mind as well.
Yes, you don't want to have one legal problem and find you have to put yourself in
Exactly.
another as well. You certainly don't want to be doing that. So James, given what we've been discussing, given the outcome of the Virgin Active case, are you concerned actually that we're going to see an increased trend of businesses taking the restructuring route, where they're looking for an easy way out of contractual commitments and at the landlord's expense?
I think we already have. I think COVID has been a catalyst. We've had probably a consolidation of what was going to be 10 years realignment of retailing into 10 months or 12 months in terms of online and a mix of bricks and clicks. And what you're now seeing is a number of, I use the word entrepreneurial occupiers that are looking at how can they realign their portfolio in order to make sure that they get the maximum out of the units that they wish to occupy going forward, and they can just ditch the rest of them and jettison those that no longer are fit for purpose or have a requirement, and they can do it almost at their own behest, with no respect for a contract, no respect for the relationship, and you're seeing this more and more. New Look have had 3 CVAs. Select have had 3 CVAs. You're seeing more and more of this, and I think you'll continue to do so. And the problem the real estate industry really faces, it comes back to what I was saying earlier, that the government sees the risk of job losses as far greater risk than the risk of a lack of real estate investment. And whereas during the great financial crisis, real estate and commercial real estate in particular was really one of the industries that was at the forefront of potentially bringing the whole economy down, because the banks had overlent and overexposed themselves to commercial real estate. It comes back to Jonathan's comment right at the very beginning about as a place for banking and its security. Today, real estate is not seen as that. That if landlords go bust or landlords go into receivership or insolvency, it's not going to affect the fundamental critical liability or infrastructure of the economy. And therefore quite happy for the Intus of this world to be allowed to go bust, because that's far less of a risk, a political risk, a jobs risk, than allowing a retailer to go bust who's going to shed hundreds, if not thousands, of jobs, irrespective of the fact that those businesses that are generally the ones that are going bust are the ones that have been poorly invested in, poorly backed, poorly supported, had the dividends taken out of them, and loaded with an immense volume of debt, which is festered by the private equity greed.
Okay, right. Well, we're not left in any doubt, James, about where you stand on this. So given this, Camilla, do you think that the restructuring route is likely to become the preferred choice? James has already talked about the fact that already we're seeing this very sharp upward trend in CVAs, but are we going to switch to restructuring?
I think picking up on something that Jonathan said earlier, I mean, there's no doubt that Part 26A is a very important new additional weapon in the restructuring armory for occupiers, but it's not going to be appropriate in all cases. And I think you're going to see occupiers sort of taking a rather bespoke approach to this, or which method suits them depending on what they want to achieve through their restructuring. So I certainly don't think it's a case where we've seen the end of the CVAs, and I don't think the new plan is that. I don't think the plan is the new CVA. I think we're going to be facing both of them in future. Plans are certainly going to be the tool of choice for the larger, more complex restructurings, because the plan enables there to be restructuring involving secure creditors and reorganization of share capital, and that's just out with the CVA jurisdiction. So they're going to be the preferred choice in that context. I think we might see a sort of COVID rush once the sort of people have had a chance to play with their toys, as Jonathan said, of use of the plan. One of the key advantages of the plan is the cross-class cram down power. So it's going to be very popular with occupiers who wouldn't be able to get a write-off of that debt through a CVA, because the debt is such that the landlords would have a power of veto in a CVA. So in that sense, the plan is a very potent tool. I mean, I think it's, as I said, it's been described as a sort of CVA on steroids, and I think that's why, because essentially, if you can't, might be able to get a plan through even if you can't get a CVA through. I mean, the main downside from an occupier's perspective about plans is going to be their expense. They're likely to be much more expensive, and certainly going to involve the occupier or its backers pushing funding for the restructuring up front. You've got to have a minimum of 2 court hearings, and so that's obviously a sort of negative point for the occupier. But on the other hand, the quid pro quo of that is they get certainty, because although a plan could potentially be subject to an appeal, you know, the reality is that once you've got a plan sanctioned, you can get on with your business. Whereas, you know, if you have a CVA voted on, there's always the chance of a subsequent challenge in the 28-day period. And if a challenge is made, you know, it could take several months to resolve. So, and just finally picking up on the kind of new toys point that Jonathan mentioned, I mean, I think it is right to say that I think market confidence in these procedures is going to be critical to their sort of the extent to which they're used in future. You know, 26A is a new procedure and it's not been fully bedded down. We've had one case involving landlords. Okay, we've got NCP coming up, but we've also got the New Look appeal, the CVA appeal in New Look. Now, I personally think probably, you know, the New Look CVA appeal probably won't be successful, but if it is, then that's clearly going to be a massive consideration, because New Look does, you know, clearly establish the CVA as a sort of effective tool if it's upheld. So
yeah,
watch this space, I think.
Yes, it's dynamic, isn't it, at the moment? So we touched on the fact that there is a story playing out in the press here, and it does pit avaricious landlords against well-known brands. And as James rightly points out, it's very real when you're talking about thousands of jobs, as you often are, particularly in retail. So where do you think we are in the court of public opinion? Is there any sympathy at all out there for the position of landlords?
I think you'll find it in the more niche and the business press, which I'll come on to. In short, I think yes, there is a very significant part to be played by the media here, and I think in some senses it's either kind of being deliberately quite cynical with the way it's reported, or perhaps there just hasn't been enough research put into it. Unfortunately, I think this narrative, though, this kind of anti-landlord narrative, if you want to call it that, it is going to be very, very difficult to change because of the economic climate that we will find ourselves in. So I did some, I looked at the recent coverage in Sky News, for example, that their headline for the Virgin Active case was thousands of jobs on the line as Virgin Active and landlords await ruling. So it's clear just from the way the headline's framed that they've kind of taken one angle of that story. And as we've heard patently, there's two sides to this coin. But I think that the issues that people are going to have with wanting to change this, and of course the media should perhaps be looking at itself from that perspective. But if you just think about your average reader and their own experiences with landlords and the whole idea of landlords, I know what I think of when I think of landlords. I think of private renting woes from being a student. And again, it sounds like a crude point, but I think that's very important when you're trying to consider how this sort of thing is going to be viewed in the general public eye, which is so important. And as I mentioned before, the kind of person who kind of shops in New Look or uses Virgin Active gyms, they're much more likely to kind of side with the brand that they are familiar with, rather than some landlords. But as I said, I think from looking at potentially the more niche, the more business coverage, there is number one, there is a greater responsibility, I think, to present a more nuanced debate, because you are obviously writing for a more informed audience. And I think thankfully they're from my own reading at least, there seems to be at least more of an attempt to show a more balanced side of things. City AM, for example, they gave decent weight to comments from the British Property Foundation, who argued against the dangerous precedent that the recent rulings have set. So overall, yeah, I think you're more likely to be given a fair shake in the business press, and I think that's completely fair enough and is expected. I don't think the media should get special credit for that, but I think it remains to be seen just how much love landlords are going to get in the mainstream press. And I think personally, as someone who is part of the media, perhaps the mainstream press needs to look at itself a bit more and try and present a more nuanced debate itself next time.
Okay, so there's PR work to be done, and at least if there's understanding in the trade press, it's a place to start.
Exactly. Yeah.
So it might move on from there. Okay, so we've heard an awful lot about this situation, and James, just a question for you, really. If we've got situation, we've got occupiers who are in financial difficulty, and many, I'm sure, have been running their businesses in a responsible way. If CVAs and restructurings aren't the answer, what is?
I want to just come back to something we picked up on earlier, actually, about the impact on the market and where this goes, because that also has an impact on where do we go. One of the big issues is obviously the impact it's having on lending. A majority of property owners and investors will borrow from banks. If you can find a bank today that is going to lend on real estate, on retail real estate today, you're doing very well. And if they will do it, in fact, we were having a conversation with one bank this afternoon, earlier today, and they were talking about looking at lending at a town centre scheme, and the rates that they were looking at lending at were not far short of double digits. Now, firstly, finding a lender that is going to be willing to lend on retail is like finding hen's teeth, and then finding one that's going to be able to do it at a commercial value is even more rare. So this is also part of the implication and the challenge that is having. Firstly, on the not just in terms of the existing borrowings and the impact that these CVAs are having on existing borrowers. We've talked about that, the impact on pensions, but the impact on borrowers and where that's going to go. And we're seeing shopping centres sell for virtually nothing today because there isn't any demand from an investor perspective. Two, there isn't any lending on it. But thirdly, there's the risk of where is this going to go, and if the ultimate, the NCP and the Virgin Active are proved to be successful, and costs, for example, go against landlords. Where does that leave investors? Where does that leave lenders? Where are the risks? In answer, where do we go here? I started off by saying I have no issue in working and understanding a business that is struggling or that has been particularly affected by COVID, and the hospitality industry has really been significantly impacted.
Yeah.
And so there are ways in which one can look at restructuring businesses and doing some deals. We talked very much earlier about market rates and how we can negotiate from a landlord perspective with some empathy. There's always extremists at both ends that prejudice what the majority do, and the press today are very much driven by clickbait in terms of present company excluded, obviously, that really want to make that headline to get people to read the articles. But the real issue is going forward. The code of conduct was in principle a great idea to try and encourage that discourse and that relationship. And it definitely needs more teeth in that respect. It needs, there's talk of some kind of post-moratorium conduct to come out, but it needs government to understand that arbitration isn't just one side says A, the other side says B, and arbitration, the arbitrator comes down an A or B, that there could be a middle ground, which is C, which might not satisfy everybody, but would be a balance and a fair reflection. And that's something that I think government, it's important, needs to understand from that respect. But also that if there is going to be a restructuring, that if a business is in financial straits, that the implication is that all parties play their part. That is both secured and unsecured lenders and creditors, okay? And especially those creditors that have taken dividends out previously. Why should they be allowed to take out dividends and not have to take some kind of penalty when they've ridden the crest of a successful wave, they've gorged on the debt and the dividends, and they are not willing to then reinvest what they've taken out? And I think that is a really core element, that some kind of restructuring has to be a fairer basis. If you look at Virgin Airlines as a great example of how restructuring should be done, Virgin Airlines went to the government and asked for it for money during COVID. And the government said no, unless you're willing to put money in. And Virgin started off by saying, we're not putting any money in. And the government said, well, we won't if you won't. So why should landlords have to put money in, which is effectively what they're doing, if the retailers or the occupiers are not willing to put money in? So I think there needs to be a structure that is far more equitable, that allows or insists on further investment, so that there isn't just a draining down of the business that will continue to deteriorate unless there is significant investment and reinvestment of the dividends that have been taken out, because otherwise it's a totally inequitable process that's being proposed. So some kind of more measured, balanced structure that allowed for secured and unsecured creditors to be treated more equitably, and I'm going to use Camilla's words, more reasonably and proportionately.
Okay, so equitable, balanced, reasonable, proportional. James, Jonathan, let's come to you on this one. Turnover rents, they might be considered to be more equitable, more of a balance, more of a partnership even, and they're often the best worst outcome from a CVA. But are they here to stay? Is this actually the way forward? And actually, is this the best environment in which to be testing something so new?
I guess the question really, or the trade-off, is certainty against uncertainty. So obviously with your normal open market rent lease, they're usually for a fixed term. You know what the rent is, you know what the rent review provisions are, you know the strength of your covenant. That's the certainty. I guess with turnover rents comes uncertainty, because there are so many variables. And also a point that James mentioned, assuming you can find a lender, the debt will typically be more expensive as well. and that would probably get passed on to a tenant. There are ways that I guess you can protect a landlord. You could impose landlord break options. You could put things in like success payments. So if a tenant's doing particularly well, then the landlord would benefit as well. You could have a look back provision. So things are evened out over a period of time. Certainly if you've got seasonal businesses, you could have a prohibition on assignments or keep open provisions. So there's lots that you can put in there. But again, as James kind of touched upon, there are confidentiality concerns. Businesses aren't really going to be divulging management accounts and all their financial data. They're going to cut off at some point. They're going to want certain things kept behind closed doors that they're not going to divulge to you. So it's a little bit of a minefield with regards to confidentiality. The other thing that's quite problematic is, how is turnover calculated? I know it goes in accounts, but we all know that there are different ways of calculating turnover. Also, if you can find that elusive lender, they're also going to be probably insisting on some form of guarantee. They probably will want some kind of reserve account, so that when rent does come in, it goes into a reserve account that the lender has first dibs on. They may want security over parent company guarantees provided to the landlord. They may also want to share in success payments. So, if there is a funder involved, it could be quite expensive. But one thing that I would say that I think is becoming apparent out of the discussion that we're having today is that there is an increasing need for certain businesses to have increased flexibility on rents in order to either thrive or even just survive. So the articles that I've been reading around this do say that there might be an upturn in turnover-based rents, certainly in the remainder of 2021 and beyond. I personally haven't really seen any at the moment, but that's not to say that they will flow through. One thing that I would say to landlords, if you're presented with a lease based on a turnover rent, is maybe it's better to negotiate a turnover rent than it is having something imposed upon you. At least you keep control of the situation and you have some say in what you're agreeing to. That, it's not used to cram down, and you find yourself bound by it. And if you're crammed down and you're bound by something that you wouldn't have voted for, I guess the other question that arises is, what happens on renewal? Are you bound by that? Where is the tenant going to be going forward? So better to keep control of the situation, I think.
Yeah, I think that's sound advice. Tom, I see we have a couple of questions that have come through. We are super short of time. One of them, quite rightly, from Roger O'Brien: have we ever had a pro-landlord climate? Well, I don't remember one, but now's the time to start, don't you think, Roger? So let's get working on that. Another question that's come through from Stuart Meadowcroft about where are the landlords in, the lenders in all of this. Well, James has touched on that in terms of availability of borrowing and the cost of borrowing given the current climate, and you've touched on it in relation to turnover, Jonathan. But I think given the shortness of time now, Stuart, if we can come back to you on that one, we certainly will, because we are going to need to round up. And I think I'd just like to hear from all the panel members, really. Where do you see us going in order to ensure that we do actually have a viable property market going forward for occupiers and investors? James.
I think there needs to be a change in psychology between property owners and property occupiers. Historically, it has been adversarial. There are, I think, and again, part of that is also the press is sort of fueling some of those fires, which it would be really great if, again, we could get that message across, and an understanding that real estate is that it provides the infrastructure for occupiers to run their business. And our business is real estate, but occupiers rely on real estate to run their business. And it doesn't matter what real estate that is today, whether it's bricks or clicks, whether it's retail or whether it's warehousing, whether it's working from home or working from an office. And if there isn't that collaborative approach, if there isn't that understanding and that increasing connectivity and supplying a product that occupiers want, and occupiers respecting the fact that landlords and property owners are taking the risk in constructing and developing and owning that, then there continues to be a discord or a disconnect between what's required and how the relationship should be. So I think the big call is to really start to look at and have respect from both sides, that landlords need to be allowed to run their business and they can't have both their hands tied behind their backs. Okay. Operators need to occupy freely to be able to run their business at cost and total operating costs that are efficient for them. But there needs to be a balance, and the extremists on both sides need to realise that actually we need to work together in order to make sure that real estate and businesses come out of what has been a really challenging period of time over the last 18 months and can provide the platform for the economy to really go and grow.
Thank you. Thank you. Camilla.
Yes, I think I'd echo that. I think from a legal perspective, I mean, the problem with the law, and I think as with the sort of debate in the press, is that it is very largely polarized. And I'm probably doing myself out of future work here, but you know, I'm a firm believer in the fact that parties who are able to resolve their differences consensually will be far better off than those who wait to have solutions imposed on them by the court, because someone's not going to be happy with it. And the reality is, I think that adopting a win-win attitude is going to be commercially the best thing to do. So I think what I would like to see more is landlords and tenants embracing third-party mediation more. Because actually that's, you know, a solution or a procedure where, they, you know, for example, owners can push for the transparency and disclosure that they want from tenants in a mediation, and really the mediator can get to grips with you know, what the parties want going forward to kind of create solutions that they can then take up. So I think that is likely to be a sort of quite important mechanism for the industry.
Thank you. Tom.
Yeah, I think first of all, I'll have to put a word into my mates at the BBC to sharpen up their reporting standards, as it seems there's been some consternation today, rightly so. But no, I'd basically just echo what James says. It sounds a bit, you know, bleeding heart, but I think there does need to be just a bit more conscientiousness on all sides, really. Just, you know, we're all just trying to act in the best interests of our businesses.
That's fair enough. Jonathan, last word.
I think obviously one thing that this pandemic has shown is it's very easy, isn't it, to order things off Amazon and not bother going out. But I think we're getting to the stage now where everybody actually wants to go out. And wouldn't it be great if we could all go out onto the high street and make it an experience where you go out? You know, I'm probably looking at it through jaded glasses, but, you know, where landlords and tenants work together and they provide something that everybody wants. That's what, in my view, where some businesses have fallen over. And if you could achieve that, I think both probably landlords and tenants can probably prosper.
Great. Well, very positive way to, and great advice from you all. That is a wrap from us. I hope the audience found this as insightful, valuable, broad, and everything else really, as I did. That just leaves me to say thank you to our excellent panel. Thank you all very much indeed. And thank you to our audience. Have a good evening, everybody. Bye-bye.
Bye-bye.
Thank you.
Bye.
Thank you.